This is Bloomberg Law with June Grasso from Bloomberg Radio.
President Donald Trump has once again suggested he'd like to extend his stay at 1600 Pennsylvania Avenue for a third term.
I would love to do it. I have my best numbers ever. It's very terrible. I have my best numbers.
Trump has frequently flirted with the idea of a third term while saying he doesn't want to talk about it. For example, in March, just a little over a month into his second term.
I want to talk about it. I'm just telling you, I have had more people say, please run again. I said, we have a long way to go before we even think about that. They do say there's a way you can do it, but I don't know about that, but I have not looked into it.
But this time, there are also those Trump 2028 red baseball caps that sat on his desk during a meeting with congressional leaders this month. There's the think tank called Third Term Project. And there's the Justice Department lawyer who, during oral arguments at the Sixth Circuit Court of Appeals, referred to a new administration being in place, quote, 3 years in the future or 7 years in the future. Joining me is constitutional law expert David Super, a professor at Georgetown Law. So, David, I reread the 22nd Amendment. It plainly states that no one can be elected president more than twice. I mean, how plain is it? How clear is it?
It could not be clearer, and it could not be plainer. It's short, it's sweet, it's to the point, and they are not allowing anyone to run for a third term.
Now, there are different kinds of scenarios out there that Trump allies have put forward. One of the arguments is that the 22nd Amendment only explicitly bars a person from being elected to more than 2 presidential terms, but doesn't say anything about serving a third term. So the theory is that Trump could run as vice president and then have whatever lucky candidate for president it is resign, and then Trump takes the White House.
That doesn't work either because of the 12th Amendment, which says that any candidate for vice president must be constitutionally qualified to serve as president, which Mr. Trump isn't.
In fact, Trump himself sort of dismissed that. He said, I'd be allowed to do that, but I think people wouldn't like that. It's too cute. Also, didn't Vladimir Putin sort of do something like that years ago where he put a deputy in to serve in his place for 1 term and then he took over?
It's rather disappointing that this country is taking its political lessons from Russia these days. But yes, what Putin did was stepped down from being president for 1 term and let a trusted ally of his serve as a figurehead president while Putin ran things as prime minister, then came back and became president again. Few problems with that. One is it's too cute. 2 is we don't have prime ministerships here, so there's no obvious alternate role for Trump to go into to serve it. 3, Russia's limit is on consecutive terms. The 22nd Amendment is a limit on total terms. And 4, why are we taking our political lessons from Russia?
And just explain, to get rid of the 22nd Amendment, what would it take?
Repealing the 22nd Amendment would take a 2/3 vote from both chambers of Congress and ratification by 3/4 of the states, which is 38 states. So you would need ratification from states like Connecticut and Massachusetts. Somehow I don't think those states are going to be working very hard to get Mr. Trump a third term.
Another theory is that Trump could become the Speaker of the House, which apparently posits that it's easy to be elected Speaker of the House. And then if both the president and vice president, who would have to be Trump allies, resign.
Yeah, I keep sending in my resume to be Speaker of the House, and nothing ever happens. I'm not sure what the problem is. In theory, that could be said to be valid. The Speaker of the House is elected, and if the purpose of electing Mr. Trump Speaker is to make him president, I think there's an argument that that would also violate the 22nd Amendment of the Constitution, but it certainly puts a thumb in the eye of popular intent. We had a 4-term president, President Roosevelt. the country across all political lines concluded that that was too much power for any individual to have, that it resembled authoritarian countries too much, and we decided we didn't want to do that anymore. And this is, yet again, Mr. Trump and his allies disregarding the people's choice through their Constitution.
Have you heard any other theories of how he could become president for a third term?
I mean, the other one, I guess, is very straightforward. Just do it and see if anyone stops you. And this Supreme Court has been willing to avoid a number of constitutional violations and most obviously declining to consider or allow anyone else to consider whether Mr. Trump was disqualified under the insurrection clause of the 14th Amendment. He may just take the position that he can run, he can do it, and he doesn't think anyone will stop him.
I guess this is hopeful in a sense because he's still talking about running and having an election rather than just staying in office?
Well, there has been talk in the past that he might do something like what you're suggesting. He made some comments about that in 2020, which I hope were not taken very seriously, certainly didn't deserve to be taken very seriously. But some of his supporters have suggested that he could somehow declare some kind of a state of emergency. Someone called it a sovereignty crisis, and suspend elections on that basis. There's no authority whatsoever in the Constitution for that. So if he were to do that, he would effectively be repudiating the Constitution.
And you think that the Supreme Court might not even step in if he decides to run for a third term?
No, I think they would. I think this court is hoping against hope that he won't force their hand by doing something completely delegitimizing, but I don't believe that there are 5 justices who have so totally lost faith in the country that they would put up with that.
I mean, it could be he's trolling the Democrats, he's entertaining his base, he doesn't want to look like a lame duck, or he just wants to continue to be the center of attention with this speculation.
Yes, I think so. Presidents have often had a lot of trouble in their second terms in office. President Reagan was unstoppable in his first term and stumbled quite badly in his second. President Bush was very strong in his first and got the Great Recession and Hurricane Katrina in the second. President Obama lost all kinds of steam by his second term, and I think President Trump doesn't want to follow that example.
And was it President Reagan who suggested getting rid of the 22nd Amendment?
He did. I'm not sure how seriously. A number of presidents get fond of the job and start thinking that the 22nd Amendment is a bad idea, but I don't think anyone took him very seriously or moved very far with it, in part because President Reagan was already of quite advanced age. Of course, President Trump is much older.
And Trump would be the oldest president in history by the time he leaves office, assuming, of course, that he leaves at the end of his second term. Trump has already done so much to expand his presidential authority. It's not even a year into his second term. He's used the specter of emergencies to impose tariffs, to send the military into Democratic-led cities, and to shoot at supposed Venezuelan drug runners at sea. Have you ever seen a president in these circumstances of peacetime exercise so much power, often using the military?
No, there's nothing remotely close to this. Richard Nixon was accused with some justification of trying to build an imperial presidency, but I can't think of anything that Mr. Nixon tried to do that Mr. Trump hasn't done much more of. And I can think of many things that Mr. Trump has done that Mr. Nixon never dreamed of doing. President Lincoln used a great many powers during the Civil War, some of which may have exceeded his constitutional authority, but not on the level of what we're seeing here.
David, do you think that of the Supreme Court cases coming up that are going to test presidential authority, is the tariffs case the most significant, or is there another one that's more significant?
The tariffs case is extremely significant because the Supreme Court is filled with self-defined textualists, and it's almost impossible to find anything like the powers the president is claiming in the text of the statute he is citing. So the court is going to have to either abandon any pretense of textualism or limit the president's authority very dramatically there. The other case that I'm watching very closely is the case involving Dr. Cook and the Federal Reserve, because the Supreme Court basically told President Trump, you can fire anyone except a Federal Reserve governor, and he turned around and fired a Federal Reserve governor. If the Supreme Court is willing to let him do that, then they are effectively allowing themselves to be humiliated by the president, and we can't really expect much of them going forward.
What do you think of Trump saying he's going to attend the Supreme Court oral arguments on the tariffs?
I think oral arguments are fascinating, and he's in for a good time. I think with most courts, when a party seeks to pressure them, the court feels considerable pressure to demonstrate its independence. If I were a lawyer at the White House or Justice Department, I would beg him not to do that.
We will find out on November 5th whether he attends the oral arguments or not. Thanks so much, David. That's Professor David Super of Georgetown Law. Coming up next on the Bloomberg Law Show, we'll look at the wrongful death trial of Los Angeles pitcher Tyler Skaggs. His wife and parents are suing the Los Angeles Angels for more than $100 million. I'm June Grasso, and you're listening to Bloomberg.
Tyler Skaggs taking the mound for the Angels.
Tyler Skaggs, a pitcher for the Los Angeles Angels, was just 27 years old when he died of a drug overdose while on the road with the team. 3 years later, Eric Kay, the former Angels communications director, was convicted of supplying Skaggs with a counterfeit oxycodone pill laced with fentanyl. He was sentenced to 22 years in prison. Now Skaggs' wife and his parents are suing the Angels, claiming the team knew or should have known that Kay was supplying drugs to players. They're asking for $18 million for Skaggs' lost earnings, as well as compensation for the family's suffering and punitive damages. Here are Skaggs' wife and mother after Kay's conviction.
I miss Tyler so much. He was my only son, and I'm not going to be a grandma. I'm not going to be able to hold a grandchild, and those things are painful. I think about that all the time.
I wonder sometimes if I'll ever be as happy as I was.
The Angels say that team officials didn't know Skaggs was taking drugs and that any drug activity involving him and Kay happened on their own time. My guest is healthcare attorney Harry Nelson, a partner at Leech Tishman Nelson Hardiman. He's the author of the book, The United States of Opioids. Harry, Skaggs died in 2019, and the civil trial has just started. Tell us about the family's claims and the Los Angeles Angels' defense.
So Tyler Skaggs died in 2019 in the hotel room on this baseball trip with the Los Angeles Angels. And his family, both his parents and his widow, brought a civil trial arguing that the Angels had a duty to protect Tyler and that they breached that duty by allowing this communications director, or former communications director from the team, to give the players access to drugs and essentially to fetch them for players, and that the team should be held liable for the death and for a significant amount of lost earnings, up to potentially at least $200 million, I think is the argument. And then the question is really what the duty of the team, the baseball team, its agents, its supervisors had to protect him from the harm of drug use and access to a supplier of drugs.
Is the judge going to tell the jury what the duty is? Who's going to decide what the duty is?
Yeah, so the question of legal duty is a question of law that a judge is going to have to instruct the jury on. That will be part of the jury instructions that the parties are going to make arguments on. And the real question is, we know that teams have a duty to protect players from foreseeable harm, and the question is really whether the harm in this case of drug use, of access to suppliers, was a foreseeable harm. And then, of course, the next question being whether the team breached that duty by allowing Kay, communications director, access to the players by failing to supervise him, by failing to intervene, as the family alleges they did.
What's the defense? What are the Angels saying?
The team's defense is that this is not something that they knew or could have known about, that Tyler Skaggs was a high-performing player who appeared to be, appropriately acting as part of the team, that there was no evidence of at-risk behavior, of sort of bad conduct off the field or anything unsafe, and that they behaved reasonably in the way that they acted, and that they didn't have that responsibility to manage this problem or the person who's really the focus of the allegations here.
Yeah, it seems like the plaintiff's whole case is based on this Eric Kay, who is, sitting in prison with a 22-year sentence?
Yeah, it really does. That's really the core argument because, it's very difficult to see how a sports team or any organization can manage behaviors that's out of sight, where there aren't warning signs. And even the plaintiff witnesses, Steve Trout, the legendary player who testified this past week, said that there was nothing that he saw in Tyler Skaggs that was any kind of bad behavior or warning sign. And everything seems to be hanging on Eric Kay and the warning signs that there was something going on. And that, by the way, is very interesting. Steve Trout testified that there were a lot of unusual behaviors, and Kay was sort of almost like a jester in the most benign sense, but obviously was doing some really terrible things in terms of functioning as a drug dealer for Tyler and other players.
During Kay's criminal trial, Skaggs' wife said that she didn't know about his drug use. So if she doesn't know about his drug use, then how is the team supposed to know?
It's a fair question, right? Clearly, Tyler Skaggs was able to keep his drug use from people very close to him and even his wife. So it is tricky to know. And at the same time, we do in our society hold employers responsible for the behavior of their employees that's known. And so Eric Kay, there clearly were concerns. There was something going on with him, that he himself was behaving in sort of disturbing ways. So it's a tough call. I mean, I think it's fair to say that the Angels, could have easily behaved reasonably and missed anything going on with Tyler Skaggs, but clearly there was something unusual about Eric Kay and his behavior.
Now, where does it fit in that there was evidence that Skaggs used drugs when he was with the Diamondbacks, and that, again, during Kay's criminal trial, his mother testified that her son had an issue with oxycodone going back to 2013. He wasn't prescribed opioids after undergoing Tommy John surgery in August 2014 because of that.
That's also, another dimension of the case, sort of player safety in terms of how much the team should have known. The Angels are arguing, of course, that Skaggs had this prior drug problems in the past, that he was drinking heavily, that he was getting pills from other places. But the point is actually, I think, a strong one that the family is making here, which is that there was a warning sign. The team should have known, because this player, players in general are at risk of so much physical and emotional mental strain in the work that they're doing, that they're inherently at risk for pain and for addiction, and that the team had a duty to be more proactive in how it monitored access to the drugs themselves. So I think it's a really interesting issue, and it could have a profound impact on how sports teams generally are monitoring risks around controlled substances, not only how they screen employees and non-players, but also how they think about, the risks associated with the game and with, its impact on players.
How much responsibility does Skaggs have for his own behavior, knowing that he had these drug problems, et cetera? Doesn't he have some responsibility as well?
Look, I think that is kind of the tragedy of, the opioid crisis writ large. Obviously, Skaggs was taking enormous personal risk and really engaging in self-destructive behavior. And, that's the case, essentially. In a way, that's every case of addiction. But we noticed it just here, particularly because this was such a supreme talent, so young, lost as a result of it. But I do think this really is a deep question within the opioid crisis. The bottom line is, yes, the people who are engaging in drug use have responsibility for their conduct, but that's because we are, right? And the question is, what do we do and where do we lay down the duty of opposing safety externally and accountability externally, because people like Tyler Skaggs are taking risks that they simply should not be.
So the cause of death, and the Angels attorney brought this out, the autopsy showed levels of oxycodone, fentanyl, and alcohol. And he said that Skaggs died due to his reckless decision to mix large amounts of alcohol with narcotics.
So clearly, this is the classic example you learn in the first year of law school about contributing factors, right? Alcohol was clearly a contributing factor, although there's no evidence that had Tyler Skaggs simply been drinking that night, that he would have died. So it was therefore not the sole cause. So there has to be some breakdown. He had some level of fentanyl, some level of oxycodone, some level of alcohol that combined to cause him to sadly to choke on his own vomit effectively under the three substances. So, the role of alcohol as a contributing factor, something that definitely intoxicated him and made things worse, is something that the jury and the judge will have to take into account what that role was. He clearly made a choice to drink significantly that night, which was part of the chain of causation here, but it's pretty clear that had he not had the fentanyl-laced pills that Eric K. supplied, we wouldn't be where we are, and he wouldn't have died that night.
So Eric K. was convicted of supplying Skaggs with a counterfeit oxycodone pill laced with fentanyl. Since it was counterfeit, does that mean that there were other harmful ingredients besides those in the pills?
No, the pills here were fentanyl-laced. So they were counterfeited pills. So essentially, like so many people have died in this crisis, it's clear that, Eric K. unwittingly gave counterfeit pills that were significantly fentanyl. It appears that there was some mix of fentanyl and oxycodone, and it's not clear to me whether those were like different pills. It's clear that Eric K. was, like many people, buying things that he thought were oxycodone and, in fact, were, street-based toxic fentanyl that he was delivering to Tyler Skaggs.
When deciding on the damages related to Skaggs' lost earnings, he was in the starting lineup, but apparently struggling with injuries. So how will each side approach this, and how will the jury make a final determination? Because with the injuries and the drug use, it might be hard to tell how successful he would have been.
The damages in a case like this are a combination of pain and suffering and lost earnings. And as you're alluding, lost earnings is the big variable, potentially, and then, of course, punitive damages. So, my view of these cases is that even if the jury holds the Angels responsible, which if I had to make a bet here, I think is the way this case will go, the jury will tell us a lot by the amount of damages that they hold the team responsible for. The plaintiffs are hoping that the jury may, impose as much as, $1 billion or $500 million of damages when you add in punitives here. The highly speculative part, of course, is how far the lost earnings would go, and it's anyone's guess how this jury is going to go. I always look at these damage awards and think that there's a largely emotional component in terms of how the jurors, how much anger and how strong of a message they're trying to send to the team about this case.
Coming up next, I'll continue this conversation with healthcare attorney Harry Nelson. This seems like a case that could have settled before trial. I'm June Grasso, and you're listening to Bloomberg. The wrongful death trial of Los Angeles Angels pitcher Tyler Skaggs comes more than 6 years after he was found dead in a suburban Dallas hotel room where he was staying as the Angels were supposed to open a 4-game series against the Texas Rangers. A coroner's report said that Skaggs choked to death on his vomit, and a toxic mix of alcohol, fentanyl, and oxycodone was found in his system. Eric K. was convicted in 2022 of providing Skaggs with a counterfeit oxycodone pill laced with fentanyl. I've been talking to healthcare attorney Harry Nelson of Leech Tishman Nelson Hardiman. Harry, you think that the plaintiffs will win here, so Skaggs' wife and his parents. Why did you come to that conclusion?
I just think Tyler's widow, I think his family are, deeply sympathetic And I think this is a case, as much as this problem of opioid overdose deaths is a just profound national crisis, Tyler Skaggs has become uniquely a symbol. And it does appear that the team, was a part of the circumstances that led to it in terms of allowing someone like Eric Kay into an official team position. It wasn't just like he was part of Tyler Skaggs' entourage. And I think in general, when you read the coverage, I do think that is a unique problem that the Angels face here, and that makes this an uphill battle for them.
I understand that, the wife suing. Is it unusual to have the parents suing?
No, a lot of these cases are initiated by parents. Unfortunately, in a crisis that's affecting so many young people, you have so many people who are unmarried or who never had children, and so it's very common to see the family suing. I think the Tyler Skaggs family have been particularly articulate about this tragedy and that have made it into a symbol. But unfortunately, I know too many parents who are in the same position and just looking somewhere for relief. And very few times can you point to an organization like a professional baseball team and say they're responsible. So many of these opioid overdose deaths, there's an anonymous drug dealer and nobody to actually hold financially responsible. So that's another piece of this case that's very unusual.
Yeah, I was going to ask you whether you've seen any other cases involving opioid deaths where the employer was responsible. I guess baseball's kind of a different scenario.
Professional sports are certainly, unusual. We've seen it also in healthcare, actually. The thing about professional sports and, frankly, sports at all, at college level as well, is that you have these medical operations around the team that lead to a much higher level of access. We, of course, see the same thing with celebrities who are able to have, doctors at the ready to get them whatever they need. And we've seen so many of those crises. Occasionally, we do see in the healthcare system the fact that people's proximity allows them, if there isn't care taken around controlled substance access there too. But that is a very unusual facet of this case, and I think one of the reasons why it's forcing us to confront these questions of duty in ways that I think will ripple out and affect a lot more of how people think about the responsibility to be watching out and protecting people from this risk.
This does seem like a case that should have settled before trial.
Yeah, I can't speak to the negotiations here, but I don't think that the team views it as a success that this case went to trial. I do know that there were offers, but the family, I don't know to what extent they decided to go to trial simply to make sure that this case received attention and to deal with the problem on a bigger level. But clearly, the exposure of the team, again, which people are saying if the punitive damages numbers were validated, could go up to $1 billion or more dollars, is really, really substantial. So the fact that this case did not settle earlier is not a good thing for the team. Up
to $1 billion? I know that some jury verdicts have been just through the roof lately, but how did they reach $1 billion here from the $118 million in lost earnings?
No, that's with the punitive damage numbers that the plaintiff's lawyers have asked for. But I will not be surprised to see this case have a 9-figure settlement, meaning hundreds of millions of dollars. So I think, the Angels are at risk. You can argue all you want that Tyler Skaggs never would have, rebounded and been a great player. But I think when people are looking at a young man with so much potential, I think the natural tendency is going to be to assume that the lost earnings are real and to give a substantial reward here.
Harry, don't you think that juries have been sort of giving out judgments that reflect jackpot lottery winnings, even in cases involving a single plaintiff? Jury verdicts are just exploding.
No question. Look, we see it in our cases that we're handling. There's no question about this whole issue of jury inflation and this trend of much higher awards in wrongful death cases, in personal injury cases, in corporate liability cases. And I think it's a real problem because, often organizations will think they have enough insurance to cover things, and then the forces, I think jurors are just less deferential to large organizations. We're living in a time when people are, more likely to distrust institutions, and people are wanting to send messages, and nothing sends a message in this context like a very large verdict. So it's definitely a problematic trend, and, I'm finding clients in much more mundane cases are encountering it just because it's like you think, that standard whatever insurance policy that you have is going to be enough. But if you get an aggressive plaintiff lawyer who is able to tell a story very effectively and really emotionally move jurors, you could be looking at a lot more exposure.
Well, the Supreme Court has set guidance that punitive damages shouldn't exceed a 9-to-1 ratio to compensatory damages. So we shall see what happens here. Thanks for joining me, Harry. That's Harry Nelson of Leech Tishman Nelson Hardiman. He's the author of The United States of Opioids. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.